it signed and results were declared. I'm putting pressure on the recorders. I'm sorry, my lords. I'm sorry.
But you agree with me? You agree with me that at the material time that you left, you have seen and certified 13 of the 16 Form 12s. Is that not so?
My lords, as far as I know, we did not certify 4 regions. So that brings those we certified to 12, because we have 16 regions. Now, I should indicate that even if it was just a single region that we did not certify, my lord, that for us was very important. The reason being that behind the numbers are the wishes of people expressed in votes. And we wanted to make sure that in the end, irrespective of who was winning, the declaration reflects the exact will of the people of Ghana.
The four Form 12s that your original agents did not sign, they also did not indicate the reasons for their refusal to sign on those forms. Is that not so?
My lords, may I refer? My lord, the 4 regions that we did not sign, the reason was not because our original reps did not sign.
Oh, please answer my question. When you make life difficult for me, answer the question. I'm saying that the 4 regions that your original representatives did not sign, they also did not indicate the reason for their refusal to sign on the forms as required by the CEI 127. Answer the question.
Yes, my lord.
Good. Are you aware that out of those 4 regions that your representatives in the regions did not sign or indicate their refusal, the petitioner won 3 of those regions?
My lord, that is precisely the point. If our interest was just in winning.
Mr. You see, we've advised you, when you answer the question, you can add whatever you want to add.
Yes, my lord.
Explanation.
Yes, my lord. Could you please take the question again, my lord?
I am saying that the 4 remaining regional Form 12s that your original representatives did not sign, out of those 4, 3 of those regional forms had the petitioner as the winner.
Yes, my lord. And that is precisely why our issue should be seen as very genuine. Yes, the petitioner had won, but we were not just interested in the winning, but also the votes and whether they truly represent and reflect the wishes and desires of the people. And we have noticed irregularities that we thought needs to be rectified. If we were there only to see forms that the petitioner was winning, I believe that we would have signed. But to the extent that yes, the petitioner won those regions, but we did not sign and had raised issues, it's a clear indication that we actually were making sure that the writing is done according to law.
According to the law, raising issues must be on the Form 12s. Did you indicate any reason on any of the Form 12s?
My lords, we did not, because we never got to the point where an opportunity to indicate reasons on the form was provided. Besides, the particular form that we are talking about, which I believe is Form 12 from the regions, had no space on the form for representatives in the strong room to put their signature and comments if they have any issues. The forms that came in as summaries did not have that particular column or space provided for us. So assuming we were even stating reasons why we were not signing, my lords, there was no place available for that.
You see, if you had any reason to refuse to certify Form 12, you would have indicated on it the same way that your representatives signed, that your colleague Rojo signed and certified on all the others. I am putting that to you.
My lords, with the greatest of respect, I don't know whether it is possible to show how Form 12 looks like in this court so that my case will be made clear. I am saying that on that form, there is no space whatsoever for writing of comments if you have any concerns. I have a sample of that form here, my lords. This is the Bono East form. The columns here have no space whatsoever.
Are you referring to a sheet from your
My lords, I'm referring to just one of the regional summary sheets.
It's coming from, it's just in your possession at the moment.
My lord, I believe so, my lord.
You must refer to what is for the.
My lord, if we go to my exhibits, the one on Eastern region, it is actually the same form.
Go. Now, can you read the right part? There's a heading. In fact, start from the top.
Okay.
Where they sign, right? Start from the left column. Read all the headings for the hearing of the court on the Eastern regional sheet that you have.
Okay. Thank you, my lords. I'm reading it, but against the background that this. Okay. Name of agent at the regional level. Party. Name of party or candidate, signature of the agent at the regional level, reason if refused to sign at the regional level.
Thank you, my lord. Now, you indicated that you have not seen Form 13. I want you to look at the petition, the first respondent's Exhibit 4.
Could you please, my lords, can I please have a copy? Okay.
My lords, whatever is being shown to him, we need to know what is being shown to him, because
my lord.
yeah, counsel for the petitioner is saying that whatever you want to show to the witness in the box, by the would I say the practice, settled practice, the counsel must have a look at it.
My lord, I wanted to show to the witness Exhibit 4.
Oh no, it passes through counsel. It doesn't take anything away. Yes.
You know? Exhibit 4 attached to the first respondent's witness statement.
I have the statement. I don't have the exhibit.
You are looking at the Form 13 regarding the 7 December 2020 elections, Exhibit 4. Is that correct?
My lords, that is not correct.
Now, the Form 13 was signed by 8 of the agents present at the time, the form that you are looking at.
My lords, that form is not in evidence at this stage. I thought that he was showing it to him in order to raise some issues about credibility, maybe if he had signed it or something like that, but that form is not in evidence, and he cannot be asked questions about the contents of that form. It's not in evidence, my lord. And the witness has stated quite clearly that no such form was presented at the time that they left. So that form cannot be the basis on which he can be asked to make references as to the...
With respect, I wish to withdraw the document
it's
from
not
you.
yet in evidence.
That's what he has seen.
Thank you.
Now, you see, at the time on the 9th that Form 13 was filled out and signed, you and your colleague Rojo Metinonu had left the commission.
My lord, at the time this form was prepared, which by the way we don't know what time it was prepared, we have been instructed by the first respondents to go and have deliberations with the petitioner on the basis of the irregularities that we have identified and had asked and had brought to her notice.
I am putting it to you that the first respondent's chairperson never instructed you to leave the commission.
My lord, the first respondent did instructed us to leave the place.
I am further putting it to you that you indeed did not even personally speak to her. She cannot instruct somebody whom she hasn't seen. Yes, my lord. Yes, my lord. Yes, my lord. Now,
yes, my lord.
But in your witness statement, you stated that she asked you to go. Why do you insist on using instruct now? In your witness statement, you said she asked you.
My lord, I believe I had said earlier that I'm using instruct and ask interchangeably.
But the two words don't mean the same thing. The two words don't mean the same thing. We all know that.
Now, I am putting it to you that all the figures on Form 13 is a summary of all. Can't I put it on?
Back to the figures on Form 13, which is not in evidence. That's impermissible.
Mr. Chikata, he has recognized that he received training for his role. So I don't think that the question refers to a specific Form 13. Form 13 is a generic form, isn't it?
I was listening to the question that he asked.
So was I.
And I did not hear him say a generic Form 13.
Neither did he say the specific one. So let's see what the witness
In the
says.
context, the only Form 13 we've been talking about in the last 5 minutes is what he sought to tender. So in the context, I think in order not to mislead the witness, if he's talking about a generic, clear, so that the witness...
That's appreciated.
My lord, I will address the court on it. Now, You were not present at the commission because you left when you realized that the petitioner had lost the election.
My lords, that cannot be true, because as at the time we were instructed to go and have deliberations with the petitioner in that room, we had come nowhere close to knowing who had won and who had lost, because the totals as they were coming from the regions had not been put together, and of course there were issues with some of them, so we couldn't have even put the totals together and decided that candidate A or B had won the election. So there is no reason why anybody should believe that we had left because we noticed that A or B was losing the election. Besides, we did not go into that room with a fixated mindset that by all means our candidate must win. We went to the room to make sure that whatever the summary sheets that were coming from the regions were reflects the true will of the people who went out to cast their votes on the 12th of December 2020.
You see, the fixation that you have is what you have just displayed in this court. Now, let us go to your exhibit that you have attached to your witness statement. Mr. Esiedun Ketia asked me to ask you about how that letter came about.
My lords, as we began noticing challenges with the summary sheets that were coming in, we considered it proper to relay the information to one, the petitioner, and two, the political party on which he stood as the presidential candidate. And as we relayed to them, we also told them that we had sought audience with the first respondent. I should say that we sought audience twice with the first respondent. In the first instance, when my colleague went, she told him that I have heard you seem to have some genuine concerns, give me a few more minutes and I will get back to you. The second instance was when she instructed that we should go and have deliberations with the petitioner and return.
But up to that point, you didn't deem it fit to register your complaint in the mode set out under CI 127.
My lords, as I had indicated earlier,
answer the question, please.
Because there was no space on the form for us to indicate the reasons.
Oh, okay. Now, did you mean this letter to be an official letter?
My lords, the question again.
Did you mean this letter to be an official letter? The exhibit attached to your witness statement, did you mean it to be an official process?
To the best of my knowledge, yes.
Now, as a lecturer, I believe that when you deliver an official process, it ought to be receipted for. Is that correct?
That is correct, my lord.
Now, look at your document and tell us where it is indicated that it was received at the headquarters or any other branch of the first respondent. Indicate for me.
My lords, there is no indication of it on the letter, but it is important to be cognizant of the circumstances of the time between the 7th and the 9th, if not earlier. The entire Electoral Commission's building was cordoned off with heavy military and police presence. That made it almost impossible for anybody to ply even the public roads that were just beside the Electoral Commission. Now, when the letter was written, at the time the letter was being brought, we were on our way to hold consultations with the petitioner. The letter was brought in by the Deputy General Secretary of the party in
Kpessa-Whyte, I'm getting confused. You are saying in one breath that you were not there.
Yes, my Lord.
So how can you give this evidence of who brought it there and all of this?
My Lord, I am speaking in respect of what I know happened.
Yes. You were not there.
My Lord, I believe that not being there does not necessarily mean that I will not have knowledge of things that may have occurred.
No, you can't. Unless you tell us how this knowledge was acquired.
The knowledge was acquired through interactions with those who were directly involved. And therefore, the letter was brought in by the Deputy General Secretary in the company of lawyer Tony Lita and lawyer Marietta Opombrew and other officials of the party. When they arrived, they had to stay behind the police military cordon off.
Dr. White,
This evidence is not admissible.
Thank you, my Lord.
If any of the persons that you have mentioned,
we are alive.
Yeah. Thank you, my Lord. They are alive. Yes. In fact, they are present.
Yeah.
So let's come back to the letter. There is no indication on it that it was received. Is that right? Yes. Okay. You also did not send the letter by email.
To the best of my knowledge, no.
You see, I am putting it to you that this letter was put out by you, your party, in the public domain to create a certain scenario in the country. It was never received by the first respondent.
That is not correct, my Lord.
I am further putting it to you that this letter was generated by you in order that you will hide your failings as an agent of the petitioner in the strong room.
That's not correct, my Lord.
And I further put it to you that this action it came about as a result of your failings and the falsehoods that you have peddled.
That's not correct, my Lord.
And I'm further putting it to you that you are not a truthful witness.
My Lord, I am a very, very truthful and credible witness.
And finally, that the petitioner is not entitled to any of the reliefs.
My Lord, to the best of my knowledge, the petitioner is entitled to all of it.
My Lord, that will be all for the witness.
Sorry.
Yes, my Lord.
Second respondent, counsel.
Now, Dr. Kpessa-Whyte, I'm putting it to you that you know that the chair of the EC has no power to instruct either you or Metronunu.
My lords, I know that.
So, I'm furthermore putting it to you that if you left the strong room, you did so on your own volition and based on your own judgment.
My lord, that's not correct.
Now, you see, part of the burden of your witness statement has been to demonstrate, as you put it in this letter, MKW1, that Ashanti region provides fundamental problems that require investigation, we have found out that almost across board, the aggregates on the summary sheets do not reflect the individual results on the pink sheets. Is that not so?
Yes, my lord.
Now, I'm putting it to you that that was the basis of your allegation in the press that over 390,000 votes had been, there are problems with them.
Yes, my lord.
Yes. Now, you admit that in the petition of the petitioner, he makes no such averment.
My lords, I believe...
No, please. No.
My lord,
I'm saying that you know that in the petitioner's petition, he makes no such averment about 390,000 votes.
My lord, he did.
Well, the court will determine that. Now, I'm also putting it to you that when, according to your tale, you were living, the two of you, one of you could have remained and the other have gone. Is that not an option?
My lords, the weight of the issues we were going to discuss with the petitioner requires both of us to be present.
So are you suggesting that if one of you went and said that, Mr. Petitioner, this is what the two of us have agreed upon, so what I'm relating to you is based on our common position, the petitioner would not have heard you?
My lord, I don't know.
That is a good question. The answer. Now, I'm therefore putting it to you that your witness statement adds absolutely nothing to the case of the petitioner.
My lord.
Mr. Akoto, this is a matter for addresses.
My lords, my witness statement.
My lords,
okay, so
that will be all for the witness.
No, thank you. But, my lords, can I?
Mr. White.
Please, there will be questions from the bench.
Dr. White.
Yes, my lord.
Kindly look at an exhibit, the presidential election regional results summary sheet.
My lords, please, I couldn't hear you.
Presidential election regional results summary sheet is attached to your witness statement.
Attached to my witness statement?
Yes, your witness statement.
Okay.
Eastern region.
Eastern region, yes, my lord.
The one with the... Mr. White, Dr. White, look at the one...
Yes, my lord.
Now look at the far right column.
The far...
Right column, the bottom part.
Okay.
Reasons if refused to sign. You say it?
Yes, my lord.
So are you seriously saying that if you had any reason to refuse to sign, you couldn't have registered it there? That column. I want you to be very... Are you seriously saying that this column could not take any reason for a refusal to sign?
My lord, with the greatest of respect, this form is designed purposely for regional representatives at the coalition center at the regional level. They are the ones who are required to sign, and a space made available for them and state reasons.
Yes.
At the National Coalition Center, my lords, no space whatsoever is provided on any form whatsoever to indicate why we have a concern and we needed it registered. And in fact, it is in consideration of that we decided that let's have a conversation with the returning officer and raise our concerns.
So you agree with me that at the regional level, there's a space for parties representative to assign reasons for not signing?
Yes, my lord, but not at the national level where I was a representative.
All right. One minute.
Kpessa-Whyte.
Yes, my lord.
You said you received training or before assuming your duties.
Yes, my lord.
So you've seen the Form 13 before?
Form 13?
Yes.
I have seen the Form 13 during the training process, yes.
All right. I'm going to show you a copy of the Form 13 that has been brought to this court.
Okay.
It's not in evidence yet, but I'm going to show it to you. Please show it to his lawyer and then show it to you. Do you see a column that is headed reason for refusal to sign?
Yes, my lord.
Thank you.
And my lord, if I may, this is not Form 13.
What is it?
Only the first respondent can answer. Because if you look into the CI 127, a sample of the Form 13 is there. It requires you to list the regions and list the candidates and their individual votes as obtained from the regions. This form only listed the candidates, the votes they obtained, and then subsequently had agents and the candidates and signature. So this is not Form 13.
So when you say that the Form 13, as you know, it does not have a place for indicating your refusal to sign, you are thinking about what is in the law?
My lord, I have not said, my lord, I have not said the Form 13 as I know it. I only said we were not given any form in the National Coalition Center that requires or has a space for us to sign.
Thank you.
Thank you, my lord.
CJ. Look, Doc, I have a very simple question. Is there a reason why there should be the two of you in the strong room at the same time?
Yes, my lord. I believe it is for us to be able to confer. For instance, the process involves a lot of calculations. And if I may, at some point, my colleague has to be mentioning the figures for me one by one, whilst I calculate them, both on the calculator and then in the Excel file. So there obviously was a reason why we have to be two. And I noticed that the CI actually says that agents must not be more than two.
All right. So if there was concern for you to leave, and in a heightened, circumstance like that, do the two of you go?
Madam, sorry.
No, please, because you see, you were there for a purpose.
Yes,
for
my
the
lord.
petitioner, his eyes, body, everything was you.
Yes, my
You
lord.
were going to confer with the petitioner.
Yes.
What were you expecting him to say? Because you were the ones receiving the regional results. So if you have to go and confer with the petitioner, wasn't it enough for one of you to go so that one stay around and see exactly what is happening?
My lord, with the
Looking
greatest,
at the atmosphere.
my lord, with the greatest of respect, the question itself suggests that the first respondent cannot be trusted.
No.
And therefore, we should have left one person there. I indicated to this honorable court, my lords, that we acted in good faith and realized later that we were deceived. And so, yes, there was that option, but we exercised the option that will allow us to give the petitioner the best of information that was available to us. For instance, my lord, whilst he was there meeting with the returning officer, I was in the strong room. he needed to inform the petitioner what exactly he was discussing at that time, and I needed to tell the petitioner what I was observing whilst I remained in the strong room. So it was important that both of us left.
Doctor, I want to be very clear on some of these issues. Now, you've already told this court that you were not sent to the strong room to take instructions from the chairperson of the first respondent. Is that correct? Your presence in the strong room was to see to the cause of the petitioner, but not to take instructions from the first respondent. You were asked this question and you admitted, you said yes.
And I indicated that.
Please, you said yes, you are not to take instructions from the first respondent.
My lord, yes.
So, when the first respondent said, go and consult the petitioner, what were you going to discuss with the petitioner? You were in the strong room for a purpose. He told you to go and consult the petitioner. On what? I want to know.
My lord, on the specific irregularities that we have brought to her attention, and she did indicate also that the reason she was asking us to do so that all the stakeholders, including the NPP, Peace Council and others, could be invited to ensure that we have a credible results before the announcement is made.
But you know that part of your duties in the strong room, at the end of the day, if you have refused to sign, was to indicate the reasons why you had refused to sign.
My lord, it appears to me that there is a particular side of this narrative that has not been very clear. I am saying with the greatest of respect that the forms that arrived in the room, and within that room itself, there has been no space whatsoever for us
No, I don't mean that. I am saying that at a point in time in the strong room, there will be a time for you to indicate your displeasures on what has happened.
My lord,
to the EC.
We know that, and we had hoped to get that opportunity, but that opportunity was denied us.
Please. Then, you see, would it be right for me to say that by taking contrary instructions from the chairperson of the first respondent, granted what you are saying is true, you did not help the cause of the petitioner who sent you there?
My lord, I don't believe that is true. We were working in furtherance of making sure that the results that ultimately gets announced by the first respondent reflect and represents the will of the people. And if she asking us to consult with the petitioner is part of how we could get there, we were happy to do it.
But then, seriously speaking, you did not take your training seriously. No, please.
It's not an appropriate question.
I want to be clear. You've gone to do a particular job. Then, instead of doing the particular job that sent you there, you take instructions from somebody else. Then you leave your job. You see, that's what I want to find out. Then you did not help the petitioner.
My lord, with respect, his lordship is entitled to his opinion about what the petitioner did. In terms of factual evidence about what he did and the reasons that he has answered. He has, in terms of, his lordship can have his opinion. That's his opinion to have, and he can have it as well. But in terms of what the petitioner did and why he did it, he has answered the question. So I don't think he can be harassed with these opinions.
Please, I take deference to that. I am not harassing the witness. It's not my duty to harass him. Well, I know that he has been sent by the petitioner to do a job for him. Then somebody tells you, oh, go to the petitioner and consult him. If the petitioner could do the work, he himself would have been there. That's what I want to find out. But how am I harassing him?
Well, you're harassing him respectfully because the petitioner has indicated that it wasn't just somebody told them that go and talk to the petitioner. The petitioner has indicated that the returning officer...
The witness or the petitioner?
The witness. Thank you for the correction. The witness has indicated that the chairperson, not just anybody, the chairperson, who is a returning officer, was the person with whom his colleague had the conversation, and on the basis of that, they were sent to talk with the petitioner. And he has given every account of why they thought it fit that both of them should go. Now, so if repeatedly an opinion is being put to him, that is harassment of the witness, and that's not allowed.
My last question.
Thank you.
My last question, Doc. Just by the way, what do you lecture at the University of Ghana? The subject, please.
My Lord, I teach public policy.
Okay, thank you.
Right. I have one more question for you. I want to be clear in my mind. You've said in evidence that you never spoke to the chairperson or the first respondent. You said it.
My Lord, I did say I never spoke to her in person.
Yes.
But I do know that my colleague had spoken to her on our behalf.
No. So how did she instruct you? The person never spoke to you. You have admitted on oath.
My Lord, I am surprised at this question.
Why?
The reason being that...
Why are you surprised?
I'm surprised because...
the question I'm asking emanates from your evidence.
Yes, my Lord.
So wait, Dr. Whyte, wait.
Thank you, my Lord. Sorry about that, my Lord.
I'm saying that you have admitted on oath that you never spoke to the chairperson.
Yes, my Lord.
So I'm asking, how was the instruction issued? Is it not a fair question? Why are you?
It is a fair question, my Lord.
So why
the instruction was issued through my colleague, Rojo Betelnunu.
Yeah. So
and on the basis of that, we had to comply. Thank you, my Lord.
No re-examination.
Order in court, please.
Counsel, may we know whether this is the last witness for the petitioner?
My Lord, we have an application in respect of our request for inspection of certain documents. And the outcome of that application will determine whether we ask leave for a further witness, because we've only filed two witness statements, and we would need to ask leave. But the outcome of the application that we have pending will affect the decision that we make.
Thank you. Yes, Mr. Amenuvor, have you been served?
Yes, my Lord, we have been served.
Okay. Yes, Mr. Ampaw.
My Lord,
have you been served?
we've been served.
Then, do you have any objection to the application?
My Lord, with respect, can the witness be...
let me discharge him. Yes.
Can he be discharged?
Yeah, certainly.
Thank you, my Lord. I'm in a hurry to go. Thank you, my Lord.
Order in court, please.
My lords, with the greatest respect, I mean, I appreciate, yes, but my lords, is it that the Supreme Court requires people to be in a suit?
Yeah, but well, we insist. It is just an advice to him. It's nothing. I'm not taking anything away from him, sir.
My lords, the only reason I rise in connection with this is that if the word goes out that whenever lecturers are coming to the Supreme Court, they have to be in suit. Because I mean, that...
Well, order in court, please.
We are raising the status of lecturers.
Sorry, Mr. Amenuvor, are you opposing the application?
Yes, my lord. So
Mr.
My lords,
Akoto,
we are opposed to.
Okay, then we will adjourn it to tomorrow. Yeah. If you have any process to file, Mr. Chika.
No, my lords.
You have processes to file. Yeah. Please, we want to. Sorry, excuse me. Please, do you want to have it argued today, or you?
Yes, my lord, it was filed today and served today. My lord, if you, with the kind permission of the court, get an hour and a half, we can come and file our opposition. If my lords want to take us later in the day.
My lord, then we might as well be given the opportunity to file it by the end of the day, and we'll argue tomorrow.
Order in court, please.
By court, the petition is adjourned to Wednesday, the 3rd of February 2021 at 9:30 a.m. for motion for an order for production for inspection of documents. If after the motion there is the opportunity for us to continue, we may do so. Thank you.
All rise.
It's day 3 of the trial in an election petition by the NDC's 2020 presidential candidate John Mahama, who is seeking to set aside the declaration of Nana Akufo-Addo as winner of the 2020 presidential polls. We've just witnessed Dr. Michael Kpessa-Whyte, who is a lecturer at the University of Ghana, answer questions from the EC's lead counsel first, Justin Amenuvor, and also the second respondent's lead lawyer. He was an agent at the National College